All right, we may have a little bit of a time delay, but this message should be broadcast to our Leadership Studies class in Thayer, Missouri. And so first of all, I'd like to say welcome, Steve and your class. We're very glad to have you as a part of this tonight. This is something we haven't tried just real often, but if we can figure out a way to make things like this go smoother, hopefully this will give you a chance to provide an extra resource to your class and give your class a chance through your texts to Rick to ask some questions to me, either at the conclusion of the presentation or, if there are questions along the way at any time. And we'll be switching back and forth between my discussion and some slides. So again, I just encourage you to text us if you have any questions, and we'll address those as we go. My name is Aaron Jones, and I'm the Dean of Continuing Professional Studies here at Drury University. And I'm speaking to you from the Olin Library on the main Drury University campus in Springfield, Missouri. I encourage you, if you're ever in Springfield, to come and check out our library. It's a great facility and impressive holdings and impressive structure in general. I also want to say thank you for choosing Drury University. We know that there are a lot of options out there in adult education, and we very much appreciate the fact that you've chosen Drury University. Our relationship with our students in the branch campuses, particularly in the South Central region, where we're being broadcast tonight, is very important to us. And so we're glad to have a chance to visit with you tonight. And hopefully we'll be able to bring something to you that's both relevant to the coursework you're working on right now, but also something that ties into an event that you may or may not be familiar with. As my slide says, and I'll ask Rick to take you to the split screen on the slide. This is American Association Mediation Week 2014. I'm providing this presentation to you because prior to serving as the dean, I became a mediator and practiced law primarily in Springfield, Missouri. If we'll go to the next slide, actually the third slide, there's a theme to this year's Mediation Week as set forth by the American Bar Association, and that is the stories that mediators tell. From rookie to veteran, exploring the spectrum of mediation. And just a word or two about the American Bar Association. Founded in 1878, it is a voluntary organization, and with nearly 400,000 members, one of the largest voluntary organizations in the world. The most recent past president of the ABA is Jim Selkenot, who's actually a 1969 graduate of Drury University. There are a number of different sections that the ABA has, including a section on dispute resolution. I'm sorry, just to give you a little better idea about Mediation Week. Mediation Week is something that the ABA started in 2011 with the idea that it would be a celebration of the strides we've made in institutionalizing mediation as one of several appropriate dispute resolution processes. And I've included, as you can see, the link to the ABA website that has additional resources. Each year there has been a theme to Mediation Week, and the most recent themes, as you can see, we've talked about civility in public discourse, from the courthouse to the conference room, making a world of difference, and now the current theme about the stories mediators tell. We find that as we go through, obviously the American Bar Association is an organization primarily geared toward lawyers, but much of what we discuss in our CCPS and Drury University curriculum, specifically in the area of leadership studies, deals with many of these things when we talk about civility in public discourse. And certainly whether we're in a legal dispute or just trying to resolve conflicts outside the legal system, hopefully there will be something that you can take away from tonight's presentation. I'm just going to flash up here on the screen a list of some different forms of dispute resolution. We'll be talking about a number of these, but the one that we mainly want to start off with is a discussion of mediation. Now, one thing that when we talk about forms of dispute resolution, I should clarify that most forms of dispute resolution involve the use of a neutral. And the duties, the roles, the powers of that neutral will vary from type to type. The qualifications of the neutral may vary. We have process experts and we have subject matter experts. And there are certain terms that we need to be wary of using interchangeably. I'm going to go to one more screen, and then I'll ask Rick to bring the camera back to me. And to give you an idea about some of the different kinds of dispute resolution forms that we use, as you can see from the slide that's up right now, there is Missouri Rule 17.01. And that is the rule of court where we find a discussion of formal methods of dispute resolution. Now, obviously, when people generally think of disputes that need to be resolved, they might think of obviously going to trial and letting a judge or a jury make a decision. But our legal system is committed to finding ways to resolve that type of dispute before it goes to a hearing. And so the rules actually outline some different methods. Now, you'll see in my slide here that, and I'm going to slide 12, that, and you may not be able to see it now, but here in a little bit we'll switch back to it. But it defines mediation as a process in which a neutral third party facilitates communication between the parties to promote settlement. A mediator may not impose his or her own judgment on the issues for that of the parties. So what that basically tells us is that in mediation, we have that opportunity to get someone who's not a part of our dispute involved and ask them to provide us with some help in resolving that from the point of view of being a neutral. Now, and I know we don't have a live connection to our classroom, but I would just ask if, Steve, feel free to take a moment to have a little course discussion on this on your end, and feel free to text back any questions or thoughts. But a few things to think about. You might just take a note or two on this if you're a student in the class. What exactly do we mean by a neutral? When we talk about a neutral, is a neutral someone who has absolutely no bias, no predisposed opinions whatsoever? And what is the value of promoting a settlement? So I'm going to ask, while we're taking a look at that, I'm going to ask Rick to go back to slide number 12, so you will get a better look at that view of the mediation slide.
Yeah, it's up now.
Okay, we're going to go on down a little further. We're going to go to slide 15. Okay, and when you look at slide 15, this gives another definition, again, out of Rule 17, where we again go back to this phrase, where a neutral third party facilitates communication. Now, we've talked a little bit about what mediation is. Let's talk a little bit about what kind of disputes that we use mediation in. I'll just switch back to me, Rick. Obviously, we're talking about mediation in the context of legal disputes that are either pending in or headed to court. Now, certainly we'll use different terms, but there's voluntary and court-ordered mediation. We also have mediation that is used in both disputes of civil law, and that could be whether it's a dispute on a transaction involving a business, whether it's a wrongful discharge case, whether it is a car accident case. And we also have mediation that is regularly used in the family law context in terms of whether it's a custody battle or perhaps addressing issues of division of assets or marital property and that kind of thing. So there are some differences, though, in how mediation is used in those different contexts. We see with mediation, we talk about in the civil mediation, we generally think of that as being something that is conducted where that the attorney and the party involved, so both the plaintiff, the person bringing the lawsuit, and the defendant, the person or entity who is being sued, will go to a mediation session with their attorney. And in that context, they will each have an opportunity to basically describe their position, make their position clear to that neutral third-party mediator. And typically, the mediator will then separate the parties, put them in separate rooms to allow for a little more freedom of discussion. There are different ways that different mediators do this, and we can talk about this in a little more detail later. But as we look at one of the differences generally between civil disputes and family law disputes is that it is not uncommon in a family law case, even for parties who are represented by an attorney, for those attorneys not to attend the mediation session, but for just the parties to that dispute to go to the mediation. Now, certainly the attorneys will be involved and pulled back in before any final agreements are typically going to be executed in the form of a written agreement, but something just to keep in mind. Now, let's talk a little bit about the general format that we have with mediation. Mediation generally, again, different mediators can do it different ways. And I should note that even though I will generally refer to the use of a single mediator, there are some mediations that are conducted by team mediators. And this may be especially useful in a situation where there are a number of complex disputes and one mediator may be bringing more subject matter expertise and another may be bringing more process expertise. But the general idea is that if we have a mediation, typically there is an opening session, and that is an opportunity for the parties to work with one another, where each of them has an opportunity to basically plead their case to the mediator. Because if you think about it, generally the mediator is going to walk into this dispute, and again, remember, that mediator being a neutral third party, it doesn't necessarily mean that that is someone who has no biases whatsoever, or someone who hasn't ever been in a similar situation as to the parties, but it's someone who tries to put their own personal opinions and personal expertise out of the equation as much as they possibly can. And so what typically they will do is, walking into this, they'll want to know, hey, what kind of case is this? Certainly if it's an automobile accident case, the mediator will probably be someone who either has or currently tries auto accident litigation. So they're very familiar with the concept of auto accident litigation, but they may not know the details of this particular case. Are we talking about fatalities? Are we talking about serious injuries? Are we talking about something where liability is clear, or are we talking about something where the parties have some serious facts in dispute? In any event, the most mediators view that the most efficient use of their time is to start with what we call an opening session. And so in that opening session, the mediator will generally explain the format, explain the rules, and each party will have a chance to make a statement. Now, you noticed on the slide a moment ago, and you can see it down on the fourth point, use of caucus. Some mediators, actually most mediators that worked with, generally will use a caucus session, which means that after an opening statement or after the beginning of the mediation, each party will go to their separate corners. They will typically go to separate rooms in the facility where the mediator's office is located, and the mediator will then take turns meeting one-on-one with each side to the dispute. Now, obviously, if something is said in an opening session, it's said out in the open where all parties can hear it. But there may be some specific things that a mediator wants to convey, or that a mediator wants to learn more about, or that one of the parties wants to convey to the mediator that they do not want to have shared with the other party. Now, a good example of this is that maybe there's a certain weak link in the case, and maybe the lawyer to the case is aware of this, and maybe the client is not, and so they focus on that. Well, I shouldn't say not aware of it, but maybe there's a dispute. In some cases, a client may use a mediation session with someone who is also an experienced attorney to get kind of a second opinion. how do you think that this will go? And we'll talk a little bit about the difference between evaluative mediation and facilitative mediation. But the general idea is that in the opening session, things are open. In the caucusing, things will generally be, or at least there's the potential for things to be confidential, which is one of the main points now. When we talk about confidentiality in the context of mediation, that doesn't mean that every single thing that you say will need to remain confidential, because if the mediator is merely carrying a number back and forth to try to get movement from either side, that probably won't be a successful mediation. What the mediator typically will want is the opportunity to carry some information or to carry his evaluation from one party to the other as the process moves ahead. Now, as I mentioned before, there will often be times where a mediator may be in a better position to help the party if they know as much as possible about the case. And so if I'm representing a client in a mediation session and we have a concern, maybe something we don't know yet, if this is an early mediation, early on in the case, we won't have necessarily exchanged all of our discovery, but we might just be very frank with the mediator. We don't want you to tell the other party this, but we are a little concerned about this aspect of our case. What do you think? Should we be concerned about that? Now the mediator, if you say, and please don't tell them that we are concerned about this. Please don't tell them about this aspect of our theory. Now, if something like that is put forward, generally the mediator will agree not to tell it. Now, obviously we have exceptions. If something is said in the context of the mediation where the mediator would have concerns that one party would do physical harm to the other or something like that, typically the mediation agreement and the rules of ethics will address those. But other than that, most mediators, there will be some procedure by which that you can confidentially communicate with the mediator. Now, I mentioned a moment ago how that there is evaluative and facilitative aspects to mediation. And that's one of the points that you looked at a moment ago. Now, evaluative generally means, hey, I'm the mediator, you're coming to me because you want me to hear both sides and to meet with both sides. And at some point, you're probably going to want me to share my theory with you as to how successful you could be when you go to court, to help you and your attorney decide if that's the way you want to move ahead, or if it might be better to take the offer that's on the table, or at least try to continue negotiations. Now, some people, some attorneys especially, really emphasize this idea of evaluative mediation. They want to make it clear that if you come to them and use them as a mediator, that they want you to provide them with your opinion, not necessarily a prediction, but your opinion of what the range on how that case could turn out is. Now, facilitative, generally that's just more someone trying to get, not really trying to get too deep into making an assessment or making a prediction, but someone who is mainly trying to just get the case resolved. Now, I put up here a couple other phrases that have popped up in mediation terminology. Some people are doing what they're referring to as holistic mediations, and that could be where that they're trying to create a certain environment in the mediation. Instead of doing a mediation at a conference table in the conference room of a law office, maybe they're doing it in a dimly lit room with couches and muffins and tea, and trying to create an environment that is more conducive to mediation. Now, transformative mediation goes along the theory that mediation can not only resolve a particular dispute, but that it can have a profound impact on the parties to the mediation, where that they actually leave the mediation with a totally different outlook on certain aspects of life that might have led to that contribution, or to that conflict, excuse me. Now, certainly, this is one of those things where we have to be real careful about putting too much stock on labels, because there's probably no such thing as a purely evaluative mediator, and probably there's never a mediation that never ever delves into any level of evaluation by the mediator. So these are just some terms that are out there, and I primarily share them just so you'll be aware of them. Now, keep in mind, on this next slide, I want to go back over a couple other things that we talked about. Again, the role of the neutral is not to force a settlement, but to facilitate a settlement. And the goal is to reach a settlement earlier and more efficiently in the legal process. Now, earlier we talked about voluntary and court-ordered. So if mediation is meant to be a voluntary process, how can that also be ordered by the court? Is that the judge telling us that you have to go to mediation and you have to settle? Short answer is no, because the court may be asking you either in accordance with a specific order of the court, in accordance with an agreement of the court, or perhaps even in compliance with a local rule of court, that mediation needs to be attempted early on by the parties. Now, one of the challenges is you want to attempt it early enough that you're saving attorney fees and expense of litigation on both sides. But sometimes if you try it too early, the parties may not have enough information or may not have fleshed out enough about the aspects of their case to know enough to really make an informed decision when it comes to mediation or settlement. Now, generally, I would just point out that there have been some rare cases where a judge, after having ordered parties to go to mediation, will sanction a party. Let's say that I'm in a dispute with Steve and we're bitter enemies and we're very angry at each other over the course of this dispute. And the judge says, Aaron and Steve, the two of you have to go to a mediation session with our mediator, Rick, and need to attempt in good faith to mediate a solution to your case. Well, if I go to the mediation and Steve says, I'll settle for $10,000, and I say, well, I'll give you $500, and neither one of us is able to compromise beyond that point, despite the best efforts of the mediator, generally, we're going to say that the parties at least attempted some version of negotiation, some efforts to settle the case. Now, the catch with that is that, is it reasonable for me to offer more than $500? Well, yeah, maybe it is, but again, it's my choice. Now let's take the flip side of that. What if I go to the mediation with Steve and Steve says he wants $10,000 and I just say, I showed up, I told the judge I'd showed up, and now I'm leaving. So I get up and walk out. Now, in rare circumstances, a court has sanctioned a party who has done that because they felt that even though they went to a mediation, they did not attempt to resolve it in good faith. Now, again, courts are generally reluctant to delve that far into it, but it is something that they have done before. Now, as we think about, one more thing I should think about is, do parties have equal power in a mediation setting? This is an interesting question because generally we would think that in most cases there will be some level of power imbalance where one party will be stronger than another, where one party, the party who is seeking to make a change may or may not have more power than the party who is seeking to keep things more the way they are. So what we need to think about is, how does that affect things, and what challenges does that pose to mediation when you have two separate sides? And there are different ways to look at this. For example, when you have a mediation with someone who may be suing a large company or a large corporation or an insurance company, you could think, well, there's a pretty big power imbalance there, because on one side you've got one person who is probably of limited means. You have an entity that is very large and probably is less limited in the financial resources it has to devote to this litigation. Now, by the flip side, there are different interests that imbalance of power, when it exists, occurs. So what we have to think about also is, what is the mediator's role in terms of addressing that? Now, generally, we keep in mind, let's go back to this very idea that mediation is a voluntary process and that the mediator is a neutral party. We've got to remember that, again, the mediator is to assist the parties in examining and perhaps reaching a settlement, but not forcing that settlement. And so here's a question I'll throw out to you to mull over for a minute. If a mediator forces a settlement or pressures really puts pressure on a party to settle, especially when there's an imbalance of power between two parties to mediation. Who is really more impacted by that? Who does that adversely affect more when the pressure is put on? And while we're mulling that over, we'll go back to the slide here.
Okay, and I have a question.
Okay, looks like we have a question.
Some of the students are asking, how hard is it to change mediators when one party has doubts about whether or not the mediator is biased?
Okay, that's a great question. For those of you in Thayer or elsewhere, it looks like we have that question. How hard is it to change mediators when one party feels that a mediator is biased? And so let me try to do my best to, and maybe we'll just take it in the context of the example that we've been using thus far. It may be that this situation, if a mediator starts to put undue pressure on a party, that very well could be the kind of situation where one party or the other feels like, hey, I'm not saying we can't negotiate this thing, and I'm not saying that a mediator can't help us, but I'm beginning to get the feeling that this particular mediator who is working on our case really does have some preconceived notions, really may be biased. And so here's kind of one of those questions that comes up. A big part of having a successful mediation, especially in the context of a civil, or for that matter, any kind of legal dispute, an important part of that is figuring out who the right mediator for the case is. Now, in my practice, in my full-time law practice a few years back, I had one mediator, or probably two mediators in particular, that I generally wanted to use when I had a case. And it wasn't because that they were biased one way or the other. It wasn't necessarily because they had a great deal of experience, even though both of these mediators had. Both of them had been very successful trial lawyers before they had changed their practices to focus primarily on mediation. But I just felt that generally those were mediators that would listen to what we had to say and would give us a fair evaluation of what we had to say, and that I felt comfortable was doing that with the other party as well. Like if I felt they were leaning on us or kind of pressuring us, I always felt like it was more of a devil's advocate type role than something where they were really trying to pressure something, and I always felt confident that that same thing was probably going on in the next room. Now, on the flip side, there were probably mediators out there that I've used that, that I wouldn't necessarily use again because I didn't feel they were that effective in a particular dispute. But ideally, a mediation session will be resolved in a day or a half day or in a couple hours in some cases. One mediator that I mentioned that I've used a lot, I had 3 or 4 cases that I mediated in front of him, and all of them were resolved within about a 2-hour period. Now, I've been to other mediations where we've been in a room or in the caucus rooms for 7 or 8 hours, and we're unable to reach a settlement. So that can happen as well. And certainly, not all cases are intended to settle, and not all cases necessarily should settle. But for those that you think should settle or that could settle, it's always disappointing when that doesn't happen. So generally, we're going to be relying on our attorneys who have, or parties who maybe have been to mediation before. Picking the right mediator on the front end is very important. And so if you're working with a lawyer who has either not mediated a case, or perhaps you're mediating it in a new place, maybe you're from Thayer or West Plains, but you were in an automobile accident down in Little Rock. Well, if you and your attorney go down to Little Rock, you might talk to attorneys down there with similar cases, or talk to people down there to see if they know mediators or have any recommendations from that point of view. Now, let's say you do go to a mediation and you feel it really isn't appropriate. In some cases, generally, I have not known of too many situations where one party was very satisfied with the mediator and the other party was very unsatisfied with the mediator. Now, that's not to say that it couldn't happen, and it's not to say that it hasn't happened, but I can think of one case where it was mediated twice. It was at different stages of the case. It was a case that had multiple parties in terms of cases that I've been involved in. And in this case, we attempted to resolve it in front of one mediator, and I don't think either side was very satisfied with that. Now, again, I don't know that that went toward bias so much, although it very well could have. But if the parties especially agree that that was not a productive mediation because of bias, is a judge going to order the parties back to mediation? I don't know. I don't know that I've ever seen a judge order a party to mediation for a second time when the initial mediation was not successful, although certainly parties have reconvened with the same mediator, but the parties could reconvene with a different mediator. So I know that was kind of a long and rambling response to the question, but hopefully that made sense. If you want any follow-up, just go ahead and text Rick back, and I'll give you a moment to do that.
I have a question. You mentioned lawyers being mediators.
Sure.
Do you have to be a lawyer to be a mediator?
Yeah, here's a question we have here. Do you have to be a lawyer to be a mediator? I would say that although generally most mediators in civil litigation disputes are lawyers, typically if it's a car accident case, most of the mediators out there are ones that will have done some automobile accident litigation as an attorney. Generally in the civil side, yes, that is the case. Now, and generally I'd say it's that same way in the family law setting, but it's not exclusively so. You are not required to be a lawyer to be a mediator. I've known of mediators who have, especially for business valuation or business litigation disputes, perhaps someone who is a valuation expert, CPA, or someone with a CFO type background, they may have some skills that a lawyer doesn't in terms of reviewing financials and assisting with a particular matter. So you do not have to be a lawyer. You do have to complete a training that satisfies the requirements of Rule 17 in Missouri. And although I would say most either are or have been lawyers, it's not something that's required. Okay, any other questions at this time? Okay. All right. We've spent a lot of our time talking about mediation, and I want to talk about some of the other forms of dispute resolution. But before we do that, again, since this year's theme for mediation is stories mediators tell, I thought I would share with you some stories that mediators do tell, because it may be that when I visit with classes, it's generally most people have not been involved in the mediation, although some have in various kinds of disputes. And some, there really is an art to mediating. There are certain things to keep in mind. And so I thought what I would do is just to share with you some different things that some of my colleagues and friends over the years have shared that they have had success with in terms of how they approach mediation. And, one of the things that we always like to talk about is how do you feel? I know how you feel. That's one of the best ways that we can try to convey empathy or a sense of understanding. I know how you feel. And I had a friend and colleague who was a mediator in the state of Tennessee, and he was involved in a mediation, I believe, of an auto accident case where a child had been either killed or seriously injured. And the very first thing he said in the opening session when he sat the parties down is, he said, I just want to say one thing at the beginning, and that is, I don't know how you feel. I don't know how you feel because I have never lost a child or had a child who had this serious type of injury. And on the flip side, I've never been accused of causing that type of injury with someone. So I don't know how either of you feel. And if you catch me saying, I know how you feel during this, I'll apologize in advance because I don't know how you feel. But what I can do is do my best to try to help you look at this case and figure out if it should settle and if there are terms on which it should settle. Another thing that same mediator would do, and different mediators take different approaches. Earlier I mentioned how that some mediators use an opening session. Well, the mediator that I mentioned that I liked to use back when I was doing a lot of this was the one who could get a case settled in 2 hours. Typically, he would not do an opening session because his thought was, hey, the attorneys have already explained to the parties how this thing works, so I don't need to take 15 or 20 minutes of their time and my time explaining it again. And chances are they've heard each other set forth their positions on this many, many times. And if we do it again, it's just going to get them inflamed at one another and get them even more upset at each other than they are going into it. So I don't even want them to see each other until we start making some movement and until we're done. And so he would start the parties off in different rooms, ask each of them to tell them their view of the case and give them a little background, and then he'd start going back room to room, popping back and forth. And he was always careful to point out, though, just because I'm over there a long time doesn't mean that they're winning me over, or that that they are telling me something that's detrimental to your case or something that's really strong about their case. Because even though I've handled these mediations before, you know, there may be a problem where I'm just having trouble understanding certain aspects of this. So that's something that I think is very important to convey to the parties. And one other thing, though, for those situations where you do want to convene people together, and again, this is purely stylistic, if you make sure the parties are properly informed about the process going in, you could do the mediation either way, either with or without an opening session. So what I think that, but one thing that I think is effective, if you're bringing the parties together for an opening session, especially in a contentious case, again, my friend and colleague from Tennessee said that he would ask people to start off not by talking about the case, not by delving into the conflict that brings them to the table at that particular day, but to start off by saying, I want each of you to tell me who you are outside of this dispute. Who are you outside of being a car accident victim? Or who are you outside of being someone who's in a fight over stock ownership of a company with your former partner? Whatever it may be. And so kind of with the idea that sometimes we get so embroiled in the dispute that that is who we are. And as long as that is who we are, that will mean that we're not only making decisions with our mind, but we're making with our heart. And that we may be letting emotion control our decisions in ways that we shouldn't. And so John always tried to get people to remember who they are in the big picture and to try to help limit the amount that case may be defining them. We're going to go back to the screen, and I'm going to take you down to the next topic we're going to talk about, and that is arbitration. And so as we're making this change in slide, again, if you have any questions, feel free to let me know. Okay, as we look at this slide, arbitration is another form of dispute resolution. It is different from mediation in that when you go to a mediation, you are asking the party to serve as a facilitator. You're asking the neutral to serve as a facilitator. In arbitration, we are asking the neutral to be a decision maker, much like a judge is. Now, sometimes an arbitration opinion may be advisory or non-binding, meaning that you're only doing it to see what decision a third party would reach in this dispute in a quasi-formal setting. And in other cases, an arbitration agreement may be binding. So I would just throw out to you, what is, well, let me ask you this. And again, please share that if you'll, Steve, if you'll take a moment to go over this with the class and text us back. What, or have any of you entered into an arbitration agreement before? Okay, I'm going to go ahead and keep talking. We may have a little bit of lag time. So if we do get a text, I'll have Rick alert me and we'll stop and address the question or comment. But I want to go to the next slide that we have. And I would suggest that if anyone in the class has signed up for a credit card, purchased an automobile, been a member of a labor union or even certain non-union employment settings, there's a very good chance that you have signed an arbitration agreement. And probably one that is what we would generally think of as binding. Let's go on to the next slide. Here are a few examples of different kinds of arbitrations. We have grievance arbitrations. And again, generally, if someone in a labor union setting is disciplined or terminated, this is what will, how that it will be resolved. We'll talk also about arbitration of contract disputes. If we have business agreements, even corporate agreements or limited liability language will often contain an arbitration clause, or baseball salary arbitration. Okay, we're going to go to the next slide for just a minute, and then I'll come back to the camera to visit with you a little bit more about arbitration.
You know our view of the slides, so it's not changing. I'm thinking it's the lag, but.
Well, let's come back to the camera. Okay, I think I'm back on the camera, and I'll go over the points in the slides. There may have been a technical issue on the slides, but we can work on that. When we talk about arbitration, I wanted to tell you about some of the different kinds of arbitration because there's something in here that's very interesting. Now, obviously, when we're talking about arbitration of an employment dispute or arbitration of a business dispute, you know, those don't sound maybe real interesting, or at least something that would really affect our, you know, they affect our livelihoods, so they're certainly important. But, you know, when we're not ready, when we're wanting to do something other than work, let's think about what's the great American pastime? Baseball. And so in baseball, we have a special kind of arbitration, baseball salary arbitration. And this came about a few decades ago as a way for the team to resolve a dispute they might have with a player over what their salary should be. Now, in most arbitration proceedings, the arbitrator will be, as I mentioned earlier, kind of like a judge. They're a neutral party that has been either agreed on directly by the parties or chosen through some mechanism that the parties have agreed to in the arbitration setting. Now, in most things, you know, an arbitrator typically has carte blanche. For example, in an employment case, they could go 100% with the employer and say, yes, the termination was warranted. They could go 100% with the employee. Yes, the termination was not merited, and you are going to get to go back to work, and you will also receive full back pay and that type of thing. Or they could kind of go somewhere in the middle. They could say, well, we'll bring you back to work, but we're going to convert your termination to a suspension, so you won't get any back pay. Now, baseball salary arbitration is a little bit different because if the team says, we'll pay this player $7,000, and the player says, I want $20 million a year, the arbitrators in those cases are bound to pick one of the two. They cannot split the baby, so to speak. They cannot attempt to force a compromise on the parties, but instead, they must pick one of those two. So think about that from a negotiation standpoint. You have to be pretty careful about how you do that in that setting. Okay, did we get another text or?
No.
Okay. We'll keep talking about now, obviously, if someone goes to court, they will likely see a judge. So we've got to ask ourselves, why, you know, what is the benefit, what is the advantage of arbitration over litigation? And I think rather than switching to the slides, I don't know if you'll be able to see it or not, but I'll do my best to go over the points we have up here. Less expensive, less discovery, and quicker. Those are 3 points that are often raised as advantages to arbitrating a case rather than taking it to a circuit court dispute. So if you were to walk down to the Oregon County Circuit Court and you pay your filing fee and you pay and you file your lawsuit, then the case will be assigned to a judge. It will go through some discovery where the parties have to provide information to one another, and it will go eventually, after it's heard by the judge, a decision will be reached. But there's a lot of steps that happen in the meantime. Now, in theory, the reason why parties go to arbitration is that they want something that does not have to abide by all the court rules. They don't want something that has to go through all the procedures, but rather they just want to try to get the dispute, perhaps in a more abbreviated type setting, in front of a decision maker who will reach a decision faster than what you would typically expect to happen in court. Now, a couple other things that we often hear as advantages of arbitration is that it is more confidential, that your dispute will be heard by an expert rather than either a judge or a jury of 12 people who may not be as familiar with the type of case you have. And there are also limits on the appeal process that will control the time and expense that it takes to resolve matters. Now, as we think about this, let's go one more slide down. Now, our expense is tied to the level of discovery. So some of the disadvantages we have when we talk about arbitration is that if we're saving money by giving up discovery, the discovery process, then we may not have, or neither party may have, all the information that it needs to get in front of the decision maker for the decision maker to make the correct decision. Now, is it quicker? If I were to walk down to the Greene County Circuit Court today and file a lawsuit today, probably, assuming that things went on an ordinary course, I'd probably be looking at getting a jury trial setting maybe 18 months out, maybe 2 years out. Now, in some places, it may not be that long. So although an arbitration proceeding could resolve a case inside 90 days or 120 days, which might be a lot quicker in some areas, in other venues, that may not be as quick. Now, when I say the dispute is heard by an expert, again, that's kind of a question. We don't, there are certain procedures we have for selecting arbitrators, but, again, you can take that with a grain of salt. And then finally, limited appeal rights. If you go to court and there are things that happen, especially if you believe that the judge made an erroneous decision, there is a set, tried and true procedure for taking that up to different levels of appellate courts. Now, in the arbitration settings, we're typically much more limited in the opportunities we have in that regard. Okay, we're going to move on and talk about the ombuds or the ombudsman. Do we have any other questions in the moment? Okay, and I'm kind of following along, and it looks like that I think our slides have stabilized a little bit here. Now, when we talk about a mediator or we talk about an arbitrator, we're generally talking about someone who is outside of an organization, someone who is a non-party. Well, when we think about an ombudsman, or the more gender-neutral version, which is ombuds, we're generally thinking about someone who is part of an organization that is one of the parties to the dispute. But in theory, that person is set up within that organization in a way in which they are insulated from other aspects of the organization, insofar as that they are not, in the truest form of the word, working for the organization, but rather they're hired by the organization to be something of an internal advocate. Now, generally, we're aware of these sometimes in employment-related cases. Sometimes we're aware of them in consumer protection type cases where a large organization may have an ombudsman. Now, sometimes large contractors that have federal contracts, as a condition of those contracts, may be required to have an ombuds so that the federal government will know that if there's someone who is a whistleblower or something like that, who needs to tell the government something or bring about a particular concern, that there's a method for resolving those disputes without identifying the complaining party. I'm going to actually skip ahead a little bit to another form of dispute resolution, and certainly if any of you have questions about any of these different forms, we can talk about those later. But Mead-Arb is one that has been talked about. It is recognized on some lists of official methods of dispute resolution, but it's not one that I've ever known of being done, and certainly not one I've ever participated in. But in Mead-Arb, obviously it's a combination of mediation and arbitration. The idea is that in a Mead-Arb process, that the neutral will start off to attempt to resolve the dispute as a mediator, and if it is not settled, then that same neutral will take off the mediator cap and put on the arbitrator cap, so to speak, and then we'll arbitrate the dispute. Now, think for a minute, and I'll give you a moment just to mull this over in class. What are the potential ethical challenges of a Mead-Arb setting? Well, if we look back at our notes and we look back at the slide on mediation, confidentiality is something that we've talked about. And so when we look at confidentiality, we put a mediator in a situation where we're building a little bit of an opportunity for a party to share things confidentially with the mediator because we think that's important. Now, in arbitration, we don't have one party talking directly to the arbitrator without the other, because we don't want the arbitrator to hear anything that the other party doesn't have an opportunity to address, because it's more of an adversarial proceeding. So when we mix those two roles, we certainly create the possibility for some very challenging ethical conflicts between the two. Now, there is a way that some have created a new form of dispute resolution called early neutral evaluation. And we'll go to the slide on that. Early neutral evaluation is different. You could almost look at it as a type of a combination of mediation and arbitration, but perhaps more of an Arb-Mead than a Mead-Arb. So as we look at this, in the E&E process, the early neutral evaluation process, the neutral serves different roles in a bifurcated manner. The neutral will provide an advisory opinion in something that's something of a mini trial, or maybe something more like an abbreviated arbitration, where instead of hearing actual testimony and actual reports, they will simply hear some summaries. And when they will attempt to give the parties a chance to see how some of their theories could play out. Now, after this miniature trial or this abbreviated arbitration session, maybe it takes an hour, maybe it takes two. And again, remember, we're talking about summaries of what witnesses would say rather than full-blown witness testimony, most likely. But the E&E neutral will then retire, prepare a written decision on what they would do that is intended to be something of an advisory opinion, not a binding opinion, not something that would have the force of law, but more of an advisory role. They put that in an envelope and do not disclose it to the parties at that time. But then, having heard, in effect, the best type of opening statement in terms of sneak preview of what the case would be if it goes to court, then they put on their mediator hat and then go back and forth between the parties to visit in more detail about that. Now, if they're able at that point to mediate a resolution, perfect. But if they're not able to mediate a resolution, then and only then will the E&E neutral share a copy of the short advisory opinion that was drafted. Only then will they share that with both parties. So it's something that is a little more well-known maybe in the West Coast, but it is something that's been identified as an option for dispute resolution here in the state of Missouri. Okay, just a couple things. A lot of these things I've been talking about, there have been different books written by this and some resources that may be out there for you, both for negotiation in general. There are resources in negotiation when we talk about some of the Harvard Negotiation Project. And I would also encourage you to look at the American Bar Association website for other resources on mediation or dispute resolution. Okay, that is really all I have in terms of prepared comments. Because we do have a little bit of a lag time, we're going to go back to this screen for a moment, and I'll give you a moment or two to confer with your instructor, and we'll take just a couple minutes to give you a chance to text us any questions or thoughts you might have. Okay, while you're, maybe if there are any questions while we're getting those in by text, just something else I would share. If you do think of anything afterwards, or if you have any other questions about dispute resolution processes or mediation week, I would just encourage you to let your instructor know, and then he can get a hold of me, or let your site director, Tammy Hathcock, know. She can get a hold of me, and happy to follow up with you. But in any event, I hope that some of this information has been useful for you, not just to the topics you're covering in your LVST class, but also things that would be informative for you just in your day-to-day lives, just for general information. Okay, we do have one question. What kind of legal cases use mediation? I'll go ahead, and again, if there are other questions in the meantime, please feel free to address those. Generally, when we think of mediation, we mainly think of it in the context of civil litigation or of family law mediation. So civil, again, that could be employment disputes, that could be automobile accident cases, that could be business disputes, oftentimes arising out of a business transaction or something to that effect. Now, family law, again, that could be for a couple filing for divorce, a couple who may already be divorced, who is seeking to change something about perhaps their child custody arrangements or something like that, maybe something on the financial end. Those are the main kinds of areas where we think of mediation. Now, do we have mediation in criminal law cases? That's a little more challenging. We may not have a mediation quite in the same method, where that we generally don't have a prosecutor and a defense attorney going to a mediation to determine whether or not someone is going to plead guilty directly. But there have been certain things that some jurisdictions are trying in terms of victim offender programs, where that, and this might really be more kind of along that line of what we talked about earlier, like a transformative mediation. That, you know, is there a benefit to getting an offender to sit down with the victim or the families of the victim and to have an interaction there to maybe better help them to understand the consequence, maybe bring some relief to a family member. I personally haven't been involved in that, but I know that is an area where that some of the principles of mediation are certainly being used. I should also note that dispute resolutions are tried not just in American cases, but sometimes in international cases. A good example of this, UNCITRAL, when we get into their disputes about internationally, there can be disputes about domain names in the internet. And so there are different international arbitrations where that there are rules governing arbitration between people from different countries. And even, for example, those of you who are familiar with the Iranian hostage situation from 1980, after that happened, there were Iranian assets that were seized by the United States, and there were arbitrations between the United States and the Iranian interests over what should happen to those, and those were held in an international arbitration proceeding. Okay, we don't see any more questions, but again, I encourage you to pass any along that you think of later or that you might think of later. And thank you very much for allowing me to come into your classroom, and thank you for helping us to celebrate Mediation Week. That's all I have. Thank you.